Hello everyone, Andrew Reed here, and welcome to part 16 of my NCA exam study guide for constitutional law. Today we're going to take a look at limitation of rights, which is a section 1 analysis under the charter. Keep in mind I'm just following along with the syllabus here to the hyperlinks therein and just case briefing. This is my own personal study guide, but you're welcome to follow along. Let's get started. So section 1 of the charter says, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. And the main case that goes to this is R.V. Oakes in 1986. So let's brief that one. From this case, I just have important points from this case. So, point 1, it may become necessary to limit rights and freedoms in circumstances where their exercise would be inimical to the realization of collective goals of fundamental importance. For this reason, Section 1 provides criteria of justification for limits on the rights and freedoms guaranteed by the Charter. So, the onus of proving that a limit is reasonable and demonstrably justified in a free and democratic society rests upon the parties seeking to uphold the limitation. The standard of proof under Section 1 is the civil standard, proof by a preponderance of probability. Where evidence is required in order to prove the constituent elements of an S1 inquiry, this will generally be the case. Then it should be cogent, persuasive, make clear to the court the consequences of imposing or not imposing the limit. A court will also need to know what alternative measures for implementing the objective were available to the legislators when they made their decisions. There may be cases where certain elements of the Section 1 analysis are obvious or self-evident. So, to establish that a limit is reasonable and demonstrably justified in a free and democratic society, two central criteria must be satisfied. First, the objective. The measures responsible for a limit on a charter right or freedom are designed to serve must be of sufficient importance to warrant overriding a constitutionally protected right or freedom. This is from the Big M Drug Mart case. The standard must be high in order to ensure that objectives which are trivial or discordant with the principles integral to a free and democratic society do not gain S1 protection. It is necessary at a minimum that an objective relate to concerns which are pressing and substantial in a free and democratic society before it can be characterized as sufficiently important. Second criteria to establish whether a limit is reasonably and demonstrably justified in a free and democratic society. Once sufficiently significant objective is recognized, then the party invoking Section 1 must show that the means chosen are reasonable and demonstrably justified, and this involves a proportionality test given to us by Big M Drug Mart. There's three important components of this proportionality test. First, the measures adopted must be carefully designed to achieve the objective in question. They must not be arbitrary, unfair, or based on irrational considerations. In other words, they must be rationally connected to the objective. Second, the means, even if rationally connected to the objective, should impair as little as possible the right of or freedom in question. Third, there must be a proportionality between the effects of the measures and the objective which has been identified as being of sufficient importance. So the more severe the deleterious effects of a measure, the more important the objective must be if the measure is to be reasonably and demonstrably justified in a free and democratic society. First case that we have here that applies these Oakes test is Alberta versus Hutterian Brethren of Wilson Colony, 2009. So the issue here, whether regulation infringed freedom of religion, and if so, whether that infringement was justified under Section 1 analysis. The background here, Alberta requires all persons who drive motor vehicles on highways to hold a driver's license. Since 1974, every license has had a photo of the license holder, subject to exemptions for people who objected to having their picture taken on religious grounds. religious objectors were granted a non-photo license. But in 2003, Alberta adopted a new regulation, made the photo requirement universal. So the photo taken at time of the issuance of the license is now placed in a facial recognition data bank. So there's about 450 of the non-photo licenses that had been issued in Alberta, 56% of which held by members of Hutterian Brethren colonies. So this colony maintains a rural communal lifestyle. They sincerely believe that the Second Commandment prohibits them from having their photograph willingly taken, and so they objected to having their photographs taken on religious grounds. Alberta proposed 2 measures to lessen the impact of the requirement, but they still required that a photo be taken and placed in the data bank. And these measures were rejected by the members of the colony. They proposed instead that no photograph be taken and that non-photo driver's licenses be issued to them marked not to be used for identification purposes. They were unable to reach an agreement with Alberta, so the members of the colony challenged the constitutionality of the regulation, alleging an unjustifiable breach of the religious freedom. The case proceeded on the basis that the universal photo requirement infringes Section 2A of the Canadian Charter of Rights and Freedoms, and the claimants had evidence saying that if their members couldn't get driver's license, their communal lifestyle would be threatened. Alberta gave evidence that the adoption of the photo requirement was connected to a new system aimed at minimizing identity theft associated with driver's licenses, and that the new facial recognition data bank was aimed at reducing this type of fraud. So both the initial judge and the Court of Appeal held that the infringement of the freedom of religion was not justified under Section 1 of the Charter. So it went to the Supreme Court, who said this appeal should be allowed and that this regulation is justified under a Section 1 analysis. Some of the rules that were used here to determine this: the bar of constitutionality must not be set so high that responsible creative solutions to difficult problems would be threatened. A degree of deference is therefore appropriate, from Edwards' books. To establish a rational connection, the government must show a causal connection between the infringement and the benefits sought on the basis of reason or logic, R.J.R. MacDonald. The rational connection requirement is aimed at preventing limits being imposed on rights arbitrarily. The government must show that it is reasonable to suppose that the limit may further the goal, not that it will do so. And next rule, while the government is entitled to deference in formulating its objective, that deference is not blind or absolute. The test at the minimal impairment stage is whether there is an alternative, less drastic means of achieving the objective in a real substantial manner. That comes from the Charkeui case in 2007. So the analysis here, using these rules in the Oak test. Regulations are measures prescribed by law under Section 1. And the objective of the impugned regulation of maintaining the integrity of the driver's licensing system in a way that minimizes the risk of identity theft is clearly a goal of pressing and substantial importance, capable of justifying limits on rights. The universal photo requirement permits a system to ensure that each license in the system is connected to a single individual and that no individual has more than one license. So the province was entitled to pass regulations dealing not only with the primary matter of highway safety, but also with collateral problems associated with the licensing system. The regulation also satisfies the proportionality test. First, the universal photo requirement is rationally connected to the objective. The province's evidence demonstrates the existence of an exemption, that the existence of an exemption from the photo requirement would materially increase the vulnerability of the licensing system and the risk of identity-related fraud. Second, the universal photo requirement for all licensed drivers minimally impairs the Section 2A right. The impugned measure is reasonably tailored to address the problem of identity theft associated with driver's licenses. The evidence disclosed no alternative measures which would substantially satisfy the government's objective while allowing the claimants to avoid being photographed. The alternative proposed by the claimants would significantly compromise the government's objective and therefore is not appropriate for consideration at the minimal impairment stage. Without the photograph in the data bank, the risk that the identity of the holder can be stolen and used for fraudulent purposes is significantly increased. Although there are over 700,000 Albertans who do not hold driver's licenses and whose pictures do not appear in the data bank, The objective of the driver's license photo is not to eliminate all identity theft in the province, but rather to maintain the integrity of the driver's licensing system so as to minimize identity theft associated with that system. Within that system, any exemptions, including those for religious reasons, pose real risk to the integrity of the licensing system. Finally, where the validity of a law of general application is at stake, the doctrine of reasonable accommodation is not an appropriate substitute for a proper Section 1 Oakes analysis. The government is entitled to justify the law, not by showing that it has accommodated the claimant, but by establishing that the measure is rationally connected to a pressing and substantial goal, minimally impairing of the right and proportionate in its effects. Third, the negative impact on the freedom of religion of colony members who wish to obtain licenses does not outweigh the benefits associated with the universal photo requirement. Most important of these benefits is the enhancement of the security of the driver's licensing scheme. It is clear that a photo exemption would have a big impact on this. The universal photo requirement will also assist in roadside safety, identification, harmonize Alberta's licensing scheme with those in other jurisdictions. So with respect to the deleterious effects, the bad effects, the seriousness of a particular limit must be judged on a case-by-case basis. So while this regulation does impose a cost on those who choose not to have their photographs taken, the cost of not being able to drive on the highway, that cost does not rise to the level of depriving the claimants of a meaningful choice as to their religious practice, or adversely impacting on other charter values. To find alternative transport would impose an additional economic cost and would go against their traditional self-sufficiency, but there's no evidence that this would be prohibitive. It is impossible to conclude that the colony members have been deprived of a meaningful choice to follow or not follow the edicts of their religion. When the deleterious effects are balanced against the salutary effects of the impugned regulation, the impact of the limit on religious practice associated with the universal photo requirement is proportionate. So ends part 16 of this study guide. Best of luck on your NCA exams. Please, if you got value out of this video, smash that like button, comment, subscribe.